We're here for an attempted larceny over 20,000 and a UTA, both of them 5-year maxes, guidelines at 0 to 17 and 5 to 23 respectively. Mr. Philippa, have you had a chance to review the report and recommendations?
I've had the opportunity to review. I've gone over them with my client. We have no objections.
Any scoring challenges?
No, Your Honor.
And Mr. Juliet, are you on this case?
Yes, I have no additions, corrections, scoring challenges.
Okay, thank you. Mr. Philippa, go ahead with anything you want to say on behalf of Mr. Doyle.
Thank you, Your Honor. By way of allocution, and I see Logan's got some paperwork in front of him that I think he wants to address the court at some point with all of this as well.
Okay.
The pre-sentence report does show a fairly troubling youth timeframe for Mr. Doyle, which I've explained to him is something that he needs to overcome and do better because of, and while it may provide some context and background, this is certainly a very scary event. In reviewing the police reports and the dash cameras, I was scared for Mr. Doyle's safety and for the safety of the officers and the community in general. I appreciate the bottom end of the guideline recommendation with the 1.5-year probation attached to all of this. Mr. Doyle, to his credit, has started doing the GED courses in the jail, even though he is early he's not receiving any jail credit for that or any of the offsets that way, but it's something he wanted to try to knock out and get done. Mr. Doyle also has 2 cases over in Emmett County that felony cases, similar cases to this, that now under Givens, he won't be receiving any jail credit for over there. So I'm not sure if that's something that the court wanted to fashion into this. I don't know if that would count as a downward departure basis to allow him to transport over there to finish his Sheboygan County sentence to be more accessible to Judge Deegan and Patrick. Is your lawyer over there? Pete Lyons.
This
is okay.
Well, I generally let the different jail administrators figure out where he's going to be. You know, I don't have a preference.
Okay. So those are my comments. Logan, do you have things you wanted to tell the judge?
Yes, Your
Okay, go ahead.
I just wanted to start by saying I truly do regret my actions and understand that that's the reason that brought me here today. And I should have never done the things I've done. I should have never took part in any of it. And I just truly wanted to apologize to the victim, Mr. Fisher, because I know that what I've done has probably affected him or even his family. And it was not right for me to do anything along the lines of any of that. And I also wrote a letter for him that if I could present that to him, or y'all could get that to him.
Well, have you reviewed that, Mr. Full?
I've not, Your Honor.
Why don't you review it first and then give it to the prosecuting attorney, and if they see fit, they can forward it over.
Okay, thank you.
Mr. Juliet, any recommendations?
Yes, Your Honor, I would ask the court to the defendant to a year in jail on both counts. I was looking through the PSI as well, and his history is troubling, and you know I sympathize with that. But at the same time, and when this was going on, he was just walking northern Michigan, Sheboygan and Emmett County, thinking that he could just take whatever he saw fit. He picked up a case in Emmett County for similar conduct and was in jail for not too long, but he eventually bonded out, and within days he picked up this offense. And I mean, I know he wasn't the driver in this case, but the court knows the facts. It put the public at significant risk of danger. So I do think a jail sentence for a year is appropriate in this case.
Great, thank you. Mr. Doyle, if you please stand for the court sentence. Mr. Doyle, you're what, 21?
Yes, Your Honor.
So you've got you know, the case here and in Emmett where you with a bunch of other young people are just stealing cars, and the circumstances, you weren't the driver in this case, but fleeing from the police, and it It's a dangerous situation for everyone involved, you, the officers, the public. The other thing that I was struck by reading this report is that you haven't finished school, but you've been working on your GED.
Yes, sir.
Okay, that's a good thing. Okay. And also both of your parents have been to prison.
Yes, sir.
So I just want to tell you, both your parents having been to prison and you not finishing your education puts you in a category that lots of people, it's easy to predict that Mr. Logan Doyle is going to go to prison too. But you need to know that doesn't have to happen. That doesn't have to happen. You get to live your life. It's not going to be your dad's life. It's not going to be your mom's life. If you want to, there's a path that's easier for you than most to end up in prison. And you're only 21 now. It probably, what I'm telling you doesn't even hardly sink in, I'm sure. But I'm telling you, you spending 40, 50 years of your life in and out of prison the next 40, 50 years is going to really suck. And that's the path that you put yourself on. You can get off that path. I can't get you off that path. Mr. Filippa can't get you off that path. Your probation officer is going to try to be an encouragement for you, but they can't get you off that path. Only one person can do that, and that's you. So you have the power to decide what your next several decades are going to look like. And I hope you choose better than your parents did. And you can have a life where you're doing good things with a family, with a job, in the community. All those things are available to you, but the window closes if you keep on this path. You got no prior record, and I'm looking at a guideline range that would let me send you to prison today. So you have less time to turn things around than some folks do. So I sure hope you take it serious. If I had to guess, sometime in the next year or two, I'm going to be back seeing you and sending you off to prison. Just that's what experience tells me. But like I said, you're the only one in the room that can prove me wrong about that. And I sure hope you do. Taking all those things into account, I am going to place you on probation for 18 months as recommended, subject to the terms and conditions in the pre-sentence report. Those include, I want to highlight for you, it includes, I want you to finish that GED program.
Yes, sir.
It includes curfew. It includes no contact with all those folks listed, Mr. Morris, Marishai, Ms. Enick. You have to keep and maintain the job. There's a crime victims assessment, $130. Court costs of $350. State cost of $136. DNA testing with a $60 fee. There's a monthly supervision fee to the Department of Corrections. And then, you know, how much jail to give you? That's the real question, right? The recommendation is at the low end to 5 months. The prosecutor wants you to do the full year. You doing the GED in the jail right now?
Yes, sir.
How many modules do you need or have?
I was meant to do my my first actual test today, but it interfered with my full year, so
Okay.
I didn't go yet.
All right. All right. I think I'm gonna I don't know. I mean, you were on, he was on bond from Emmett and then committed this, and then you're getting a benefit for this not being consecutive. I think on the balance, I'm going to order that you serve 7 months in the Sheboygan County Jail with credit for 80 days previously served. I'll indicate on the judgment of sentence that if the jail determines you eligible, you can participate in the CBT program and the GED program and get credit for your sentence. So you get credit against this sentence for every module you complete on a GED, okay? All right, within 24 hours of your release from jail, I want you to contact the probation department to get you going on probation. You're eligible to be discharged from probation at the halfway point. if you've completed probation. So we're going to give you a piece of paper explaining that. If you want to appeal, you got to file an application. If you want a lawyer, you have to do that within 6 months. So we're going to ask you to initial a copy of your appeal rights. So we have a record we gave it to you. The other copy is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Doyle?
No.
Okay, good luck to you.
Your Honor, is there a work crew? Is that, or is that what CBD?
There is a work crew, but I don't allow it on felony sentences.
Okay. And the letter seems suitable in here.
Okay, very good. Yeah, Mr. Juliet, you can review that and pass it along. if you think. Yes.
Probation. Yep. Don't forget. That's some folks screw up on that.
Oh, Mr. Keel. Mr. Texter? All right, this will recall people be Robert Texter, files 25-7040 and 7051. Counselor, state your appearances, please.
Prosecutor, Wayne County Prosecutor.
William Keel on behalf of Robert Aaron Texter III, seated to my right.
Okay, good afternoon, and we're here for sentencing on an absconding habitual third with an 8-year maximum, 0 to 25 guidelines range. 7051 is a no security 1-year misdemeanor and a maintaining 2-year high court misdemeanor, 0 to 9 months. Have you had a chance to review the report and recommendations?
I have, Your Honor.
Any additions, corrections?
A couple of corrections, I believe, to start with, Judge. As far as the jail credit, I think it's accurately depicted on page 1 of the investigation report as far as dates, but then later on in the recommendation, it doesn't reflect that jail credit. Although I think he would certainly be entitled to the credit for the no insurance and the maintaining charges. So I think he would be entitled to 63 days credit for those 2 particular counts on the recommendation.
I see that on page 2 of the CFJ 145. I've got the recommendation for 62 days credit in 7040 and 63 days credit in the other file.
That's correct.
Okay.
And I'm just looking down at the recommendation. It's, I guess.
Oh, the narrative recommendation. Okay.
That's correct. And I think that, I think the no security and the maintaining, I think he's entitled to that time. Actually.
Yes. Okay. Yeah, it's my intent to give him credit for that.
Okay. And then the only other requested changes to the PSI would be concerning the language in the narrative portion, the recommendation narrative and other portions there. This was charged as absconding or forfeiting bond. This was clearly a forfeiting bond case. My client was residing at the address that he had provided the district court at the time he failed to appear. And actually, since he's on the registry of the state, he actually registered twice with the sheriff's department up in Marquette County while he had not appeared in court. So he had never tried to leave the state or to hide himself. So in all the areas where it says convicted of absconding from bond, it would be our position that he's convicted of forfeiting his bond, and that all the references to absconding should be redacted and replaced with forfeiting bond, because I think that's technically what he's guilty of here.
Okay.
And I have the different places on page 2, first paragraph, last sentence towards the end, it says absconding from bond. It would be our request that be changed to forfeiting bond. the next area is under same page, recommendation narrative. 4 sentences from the bottom, it says he failed to appear to that hearing and absconded from his bond. I think that should be rephrased as forfeited his bond. Page 4, second paragraph, first sentence, or I'm sorry, second sentence, he was charged with absconding from bond. He was actually charged with absconding or forfeiting bond, but technically he pled to forfeiting his bond.
All right, I mean, I think as a colloquial matter or as a shorthand, we all use the word absconding. You are correct, there is a bit of a legal difference there. And the factual basis here would be a forfeiture of that bond. So I guess, can we pass along to Agent K-9 then? The only spot that I could really track where that was, honestly, was on the CFJ 284, page 2, the recommendation narrative. It says he failed to appear to that hearing and absconded from his bond. If we can remove the phrase absconded from and substitute forfeited his bond, and then direct Agent K-9 to just check everywhere else in the report where it says absconding, if you can just substitute forfeit.
Thank you, Your Honor.
Okay, thank you. Any other changes?
No, Your Honor, thank you.
Ms. Goodrich, any additions, corrections, or scoring modifications, or scoring challenges from the people?
No, Your Honor, except for on page 2, when they make the recommendation as to what the sentencing should be, I thought credit wasn't given because of the absconding being discretionary consecutive, and you're recommending that it be.
Where are you seeing that? You both
On the
made some-
CFJ 145,
Okay, page what?
page 2, on the upper charts, it gives the credit, but on the lower where it makes the recommendations, 1, 2, 3, 4 under each count.
Yeah, I have, my copy says credit.
Okay,
Oh, I'm sorry. No, then it says credit for 1 day served.
right.
Oh, I see that. I see.
And I
that.
read it because I thought that they were trying to say it should be discretionary.
Oh, gotcha. Okay. All right. Well, because on the directly under count 1 and count 2, it says it's respectfully recommended the defendant be sentenced to so many months incarceration with credit for 63 days served. But then paragraph 1, the credit doesn't track down into that. Okay. Thank you. I wasn't tracking on that.
Does your copy, Judge, under count 1 recommend time served or credit for time served on page 2?
It says on count 1 of 7051,
Correct.
it says it's recommended the defendant serve 3 months incarceration in Sheboygan County Jail with credit for 63 days served. And then paragraph 1 says you must serve jail time as follows: 90 days with credit for 1 day served.
And that's under 7051.
Yeah.
I think I think where the discrepancy is the first case in time was the no security and maintaining case.
Yeah, I'm doing concurrent sentencing.
Okay, okay, fair enough. I guess that
All right.
kind of eliminates that issue.
There you go. So Agent Martin, can we tell Agent K-9 on page 2 of the CFJ 145, there's a discrepancy in his recommendations. In file 7051, he simultaneously recommends credit for 63 days served, but also credit for 1 day served. If the 1 day can be changed to 63 in both instances, that would correct that discrepancy. Okay, thank you. All right, I had missed that earlier when you said it, Mr. Keough, so I'm glad Ms. Goodrich repeated that.
Thank you, Judge.
I was paying close attention to you. I just didn't catch it. Okay. All right. So Mr. Keough, go ahead with any allocution on behalf of you.
Thank you, Your Honor. I've been representing Mr. Texer for some time, and I think it's important for the court to understand a few things about Mr. Texter. Obviously, he does have a lengthy criminal history, but since the case that he caught prior to this particular 2 cases that he caught, he had been essentially out of the criminal justice system for approximately 13 years. So I think some of that happened earlier in his life, and he obviously had some issues. But really, for almost a 14-year period, he had absolutely nothing in the criminal justice system. And then he had a possession case, which has been pled down to maintaining a drug house. And while he was on bond on that case, he failed to appear in court and obviously wasn't complying with any of his bond conditions. But I just wanted to emphasize the court, and the reason why I made a distinction between the absconding and the forfeiting is I was reviewing the jury instructions. The one thing that struck out is how absconding is more of a direct attack on the criminal justice system from the standpoint where somebody actively hides themselves to avoid law enforcement, or someone actually leaves the state to avoid a criminal case. In my client's situation, while he indeed did fail to appear in court, he never left his residence. He stayed in the exact residence that was on file with the district court. Now, he didn't come to court. He didn't comply with any of his bond conditions, which we don't dispute. He did get approximately 63 days of jail time or 62 days of jail time as a result of those violations by not being able to make bond and having his bond canceled in that case. But while he was there, he was still working, and he was also, and as a registered offender, he was actually registering still with the sheriff's department in Marquette County while he had failed to appear. So he wasn't making active steps to avoid law enforcement. He certainly wasn't making any active steps to show up in court, but he was not taking affirmative steps to avoid by hiding or leaving the state. So I wanted to make an emphasis on that. So he has suffered jail consequences for those bond violations. And he has been on bond for some time here. I know that there was one issue that he had that I think has been addressed, but I think overall his bond, he's done quite well on bond in this case. And I think he's here today, and I'm impressed with how well he has done. Now, taking a look at his record, this is his first drug offense ever, and he forfeited bond when he failed to appear on that drug offense. I've seen the recommendations. I think the position that he somehow is not amenable to probation or listening to the court's direction is not necessarily fair. I think there is an argument to be made that probation would be a more suitable outcome considering the jail time he's already served and considering the fact that he is working and he is trying to stay productive. And incarceration for the recommended 9 months seems to be a little bit harsh considering what was actually happened in this case, considering it was his first drug offense ever and considering the fact that he didn't take active steps to evade law enforcement. So with all that being said, we would ask the court to consider a sentence of probation instead of additional jail time. I do think that with his stability where he is up in Marquette, and he's lived there for quite some time, and in being compliant with other areas of the law that he does have to continue to comply with, I think probation and his ability to stay out in the community and be productive and make money, I think is more important than him just sitting and being incarcerated for a substantial time. I thank the court.
Thank you, Mr. Kehoe. Mr. Texter, you don't have to say anything today, but you're welcome to. Anything you want to tell me, sir?
I just want to apologize for being late today for the weather. That's my fault. And the absconding is my fault. And the drug possession, I know who's his friends, who's not friends, who's out of my car, not my car. And it's like about 14 years sober. I never had a drug case in my life. And it's like about who really your friends are. Be sure who's in your car. You check what they got on you first, because they're not in trouble. I am. Then I was going to say I'm sorry for the courts, wishing your time and every year before our driver and everything else. So I apologize for everything, and it's all my fault. Thank you, Your Honor.
Okay, thanks, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, the defendant is 46 years old. He has 2 felonies and 4 misdemeanors. We had a plea agreement to not exceed a total of 12 months combined for both files. He is self-employed with a high school diploma. I do appreciate the defendant's statements here today, because he basically went back to his home and said, hey, I'll see if they come and get me. And by playing that game, what it actually looks like is we have to take a deputy off the roads in Sheboygan County. We have to have them drive up to Marquette to pick him up. We have to have them transport and lose all that time coming back to address when he forfeits his bond and no longer shows up to court. So it is a serious matter. It is draining on resources. There are reasons why people have to show up for their court hearings. And I think that the PSI recommendations accurately address that. Thank you.
Thank you, Mr. Texter. If you please stand for the 4th sentence. Well, your attorney and the prosecutor have both described, true but different aspects of the case. One is that this isn't the worst absconding charge that we see, given that you were still showing up and registering and being at your address. But by the same token, it's not nothing, because then, we got to send somebody up, and that takes a lot of time and resources out of this community for what they could be doing otherwise. So you do have some prior record. There is a 10-year gap, so some of that doesn't score, and that's a good thing, that you've got a period of time of 10 years or more without getting any trouble. So that shows us that you're capable of doing that. And this was a case, I understand that, you've got perhaps a different understanding of the drugs in the car than maybe what the police or prosecutor assumed what was going on there. And you had the right, to present that to a jury, but you had the no insurance thing. And so I guess that was a manageable situation.
Oh, yeah.
And then you made it more complicated by just kind of checking out of the court case.
Well,
And then those cases just don't go away, so you didn't show up. And so then, so then you just made life harder on yourself, is my point, right? Rule number one when you're in a hole is stop digging, and you just kept digging a little bit. But I do think, taking all these things into account, although plenty of times we do impose consecutive sentence for absconding or forfeiting, in this case, I think concurrent sentencing is fine here. There's a sentence agreement for a county cap. The guidelines are straddle cell, but a pretty low straddle cell in the first one, 0 to 25, 0 to 9 in the other file. So I think on the balance, it's going to be the sentence of the court, Mr. Texter, in file 7040, that you served 6 months in the Sheboygan County Jail with credit for 62 days previously served. It's a crime victims assessment of $130, state cost of $68, court cost of $350. That's within the advisory guidelines range and the plea agreement. Count two, the no insurance, in 7051. Both those counts order that you serve 6 months in the Sheboygan County Jail with credit for 63 days served. There's $118 in state cost and $130 in the crime victims assessment in that file. Those sentences will run concurrent with each other. I'm not going to place you on probation then. And then if you wanted to appeal, you can file an application to the Court of Appeals. If you wanted a lawyer appointed, you got to make that request within 6 months. We're going to hand you a piece of paper in both those files about those appeal rights. Ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. Any questions for me, sir?
no, yeah.
Okay.
The 3 months correct, so 3 months.
Yeah, you're.
So 3 months, and so that means a month and a half. A month and a half.
Thank you, Your Honor.
Okay, thank you. Does that conclude your matters, Mr. Chair?
It does, Your Honor. Thank you.
You have any other business today, Mr. Fluff, or are you just hassling the prosecutor?
Hassling the prosecutor, Your Honor.
Multitasking is a better word, okay? All right, Mr. Gilbert, I've got Miss Abbott zooming in. All right, this is People v. Brittany Abbott, file 25-7088FH. Got Mr. Gilbert in the courtroom for the defense, Ms. Goodrich for the people. Ms. Abbott, it looks like he's trying to connect here.